Okay, we're gonna continue with right to property, and I asked you to put it in the perspective, put it in comparison with restriction on other rights, and the fact that the state can restrict property right just by making compensation without meeting the means test, right? That means that the state can restrict that right more easily than restricting other rights. But the other aspect is that the state is required to make compensation even when the state is required to make compensation even when it proves that it has a public purpose, means that property right is protected strongly, right? So it has both sides depending on how important do you think the compensation requirement is. And we looked at Midkiff case where for land equality, the Hawaiian government allowed condemnation by tenants, right, on single-family houses. And what did the court say? Did the court say this is for public purpose? Yes, right? We read the third paragraph on page 303. The people of Hawaii have attempted to reduce the perceived social and economic evils of land oligopoly, right? And then toward the bottom, the mere fact that property taken outright by eminent domain is transferred in the first instance to private beneficiaries does not condemn the taking as having only a private purpose. And then I gave you an example of how transfer to a private party is considered also legitimate taking under the Korean Constitution. So all these redevelopments, residential redevelopment and commercial redevelopment, they all involve forcing people to turn over their ownership, their land ownership, to other private persons, right? Not to the government, but to other private persons. Now, let's move on to page 305. Pennsylvania Kohler versus Mahon. So this involves when property right is triggered, or when the constitutional provision under property right is triggered. So what happened in this case? What did the government do? The Kohler Act, right? The second paragraph on page 305, second paragraph. The statute forbids the mining of anthracite coal in such a way to cause the subsidence substance 이제 붕괴죠. Of among other things of any structure used as a human habitation with certain exceptions, including among them land where the surface is owned by the owner of the underlying core and is distant more than 150 feet from any improved property belonging to any other person. So the question is whether this involves taking of property at all. The government actually did not condemn the land, right? The government did not take ownership of the land. They just passed a law. Hey, digging coal under human habitation is dangerous. Don't do it. That's all they did. But it reduces the value of the property by a great deal. Does this constitute a taking? Or is this more like restriction of, freedom of business or freedom of occupation? So it will be covered by, Article 14th Amendment, substantive due process clause, or will it be covered under the takings clause? Takings clause is the clause concerning property right. How would Korean constitutional law decide on this case? Will this be covered under the property right provision, or general, Article 37? Proportionality test. Think about it, okay? Page 306. It is all the way at the top. It is our opinion that the act cannot be sustained as an exercise of the police power so far as it affects the mining of coal under street or cities in places where the right to mine such a coal has been reserved. What makes the right to mine coal valuable is that it can be exercised with profit. To make it commercially impracticable to mine certain coal has very nearly the same effect for constitutional purposes as appropriating or destroying it. This we think we are warranted in assuming that the statute does. Right? So what the court is saying is, hey, this triggers a property right. And because the government didn't take the ownership, the government didn't make a compensation. So that's why this is unconstitutional. Now, the term police power, don't be misled. It has nothing to do with the police. Okay? It just means general power to look out for safety of people. And that's what the police were supposed to do. That was the original reason we created and invested in the police. It confused a lot of scholars in Korea because I received a paper written by somebody at 경찰대학교, at Police University, thinking that this was about them. It's not. Okay, this is about there's a power of so when when the court says something is within the police power, it's asking whether it's constitutional or unconstitutional. So the paragraph below, the second paragraph, 1, 2, 3, 4, 5, 6th line. The protection of private property in the Fifth Amendment presupposes that it is wanted for public use, but provides that it shall not be taken for such use without compensation. Here, there is no compensation. Therefore, unconstitutional. Paragraph below, the general rule at least is that while property may be regulated to a certain extent, if a regulation goes too far, it will be recognized as a taking. In general, it is not plain that a man's misfortunes or necessities will justify his shifting the damages to his neighbor's shoulders. We are in danger of forgetting that a strong public desire to improve the public condition is not enough to warrant achieving the desire by a shorter cut than the constitutional way of paying for the change. So, this must make you think deeply about what the state can do if the state has to pay for every time that it reduces property value or value of the property that people have. A lot of people own guns in the United States, and people are asking for more strict gun control after school shootings. So if more strict gun control is passed, owners of the guns cannot use the guns as much as they like, and they cannot sell the guns as easily as they could. So the value of guns will go down. Doesn't mean it is a taking and it has to be paid for. A lot of people own stocks in tobacco companies, right? Cigarette companies. Let's say for public safety, the government passes a law restricting smoking. That will reduce the value of the stocks that people have in the tobacco companies. Does the government have to pay for the reduction in the stock values, in the stock prices? Where do you draw the line? Then we come to page 309, Penn Central Transportation versus New York City. There's again a case of public regulation reducing the value of a property. So, Grand Central Terminal has existed for a long time, and it's a historical landmark. Just like, Seoul Station. It has existed since Japanese colonial period, and our successive governments have preserved it for its landmark value. Now, the third line, page 309, third line, New York City adopted its landmark preservation law in 1965. The city acted from the conviction that the standing of New York City as a worldwide tourist center and world capital of business, cultural government would be threatened if the legislation were not enacted to protect historic landmarks and neighborhoods from precipitate decisions to destroy or fundamentally alter their character. New York City law is typical of many urban landmark laws in that its primary method of achieving its goals is not by acquisitions of historical properties, but rather by involving public entities in land use decisions affecting these properties. So, okay, let's read a little bit more. But rather by involving public entities in land use decisions affecting these properties and providing services, standards, controls, and incentives that will encourage preservation by private owners and users. While the law does place special restrictions on landmark properties as a necessary feature to the attainment of its larger objectives, the major theme of the law is to ensure the owners of any such properties both a reasonable return on their investments and maximum latitude to use their parcels for purposes not inconsistent with the preservation goals. Page 310. Well, yeah, page 310. The law was at the top. The law was administered by Landmark Preservation Commission, which identifies especially important properties as designated landmarks and historic districts. Final designation as a landmark results in restrictions upon the property owner's options concerning use of the landmark site. First, the law imposes a duty upon the owner to keep the exterior features of the building in good repair to assure that the law's objectives not be defeated by the landmarks falling into a state of irremediable disrepair. Second, the Commission must approve in advance any proposal to alter the exterior architectural features of the landmark or to construct an exterior improvement on the landmark site, thus ensuring that decisions concerning construction on the landmark site are made with the due consideration of both the public interest in the maintenance of the structure and landowner's interest in use of the property. And then 2 paragraphs down, right in the middle, this case involves the application of New York City's landmarks preservation law to Grand Central Terminal. Is Grand Central still in New York? Yes, it's still there. It is that Grand Central Terminal, and it's still in use for the purpose that it has been used for last 100 years. The court noted that the terminal is one of the New York City's most famous buildings and that it had been designated as occupying a landmark site. Okay, this is where it gets interesting. Penn Central submitted 2 plans to Commission for construction of an office building atop the terminal. One plan called for a 55-story office building, another called for tearing down some of its facade and constructing 53-story office building. The Commission denied the permission to go forward with the plans. Toward the end of the paragraph, the Commission said, to balance a 55-story office tower above a flamboyant Beaux Art facade seems nothing more than an aesthetic joke. Quite simply, the tower would overwhelm the terminal by its sheer mass. So, imagine Seoul Station, right? And they wanted to build office building atop. And the commission denied it, saying, this is aesthetically, you are destroying the landmark. You are not physically destroying the landmark, but you are aesthetically destroying the landmark. But they want to build a 55-story building. Imagine how much profit the landowner would have made. Imagine how much money they are losing by not being able to build a building. If this is not a taking, what is? If this is not a taking that requires the state to pay compensation, what is taking? So, what do you think? Do you think the government should pay for the money, if not all the money, but at least part of the money that the landowner is losing? I mean, there are similar things going on in Korea, right? In much smaller scale. You go to traditional Korean houses. They cannot, if you go to Jeonju, you'll see them. You'll see these traditional Korean houses with the placards out, with like terribly angry statements, like, you are killing us here. If you want us to die, we'll die here, right? The placards say, right? I mean, they want to fix up the houses. They cannot, because it's all designated as 문화지구, 뭐죠? Cultural something. So they cannot convert. They cannot build 2-story, 3-story buildings. They cannot turn to Western style or modern style buildings. All they can do is they can receive money from the government to fix up and upkeep, maintain the traditional Korean houses. But here the scale is much bigger. It's a 55-story building. Okay, how does the court decide? At the bottom of 310, in engaging in essentially ad hoc factual inquiries, the court's decisions have identified several factors that have particular significance. The economic impact of the regulation on the claimant, and particularly the extent to which the regulation has interfered with the distinct investment-backed expectations. Investment-backed. So when people buy a property, there must be an expectation, right? So too is the character of the governmental action. Taking may more readily be found when the interference with the property can be characterized as a physical invasion by government than when interference arises from some public program adjusting the benefits and burdens of economic life to promote the common good. So, two factors, right? Whether it interferes with the investment-backed expectation, that's one. Second is the nature of the restriction. Is it physical or non-physical? And on that, there are the court goes through some previous cases. One is 2 paragraphs down, the court talks about zoning laws. The 3rd paragraph on page 311. More importantly, for the present case, in instances in which a state tribunal reasonably concluded that the health, safety, morals, or general welfare will be promoted by prohibiting particular contemplated uses of land, this court has upheld land use regulations that destroyed, adversely affected recognized real property interest. Zoning laws are the classic examples. Zoning laws generally do not affect existing uses of real property, but taking challenges have also been held to be without merit in a wide variety of situations when the challenged governmental action prohibited a beneficial use to which individual parcels had previously been devoted and thus caused substantial individualized harm. So, zoning law is that, for instance, prohibits a restaurant to be opened or bar to be opened in a residential district. So those laws have been considered not taking. Now, what if a zoning comes after the things were built? The court is saying, hey, even then, right, the paragraph I just read, even then the taking challenges have not been accepted. Right below, we emphasize what's not in dispute. Because this court has recognized in a number of settings, state cities may enact land use restrictions or controls to enhance the quality of life by preserving the character and desirable aesthetic features of a city. Appellants do not contest that the restrictions imposed on its parcel are appropriate means of securing the purpose of New York City law. Appellants also accept for present purposes both the parcel of land occupied by the Grand Central Terminal must, in its present state, be regarded as capable of earning a reasonable return, and that the transferable development rights afforded appellants by virtue of terminus designation as a landmark are valuable, even if not as valuable as the rights to construct above the terminal. So, Grand Central Terminal is still operating, so the owner is still making some money, a reasonable return. And also, I don't know what transferable development right is. I think that involves making money off of the landmark. Selling souvenir and contracting with other buildings to make use of the Grand Central easier, and the use of neighboring buildings. So, I mean, these are in the previous paragraph. Okay, zoning law has been upheld as constitutional, which means it has been considered not taking. Okay, and zoning law that came after the things were already built was considered constitutional. Actually, I mean, zoning law for future purposes, zoning laws affecting future use, I mean, that will not involve taking because people will buy things, people will buy things after. I mean, zoning before the things were built will not affect any existing property, right? So what's important is, how about zoning law after things were built? The court says it was okay. And this case, Penn Central, is about zoning after the things are built. Because Grand Central has existed before 1965. The landmark law came after that, right? So when people bought the land, it's the railroad company, Penn Central. When Pennsylvania Central Railroad bought the land, they didn't think that it will be, I mean, they didn't think about a new law coming in like, several decades later. I mean, they themselves didn't know that the station will remain for that long, right? And because their business was so successful, now it's considered a landmark and they cannot do anything about it, right? Who would have expected that? It's like, I ran this business at this place for 200 years, and for doing so, now I cannot make money off of it, right? So they never expect that. That's why this is a difficult issue. But some of the facts are important. Basically, that they can still make a reasonable return. In its present use, it is generating profit, revenues for the landowner. Now, appellant, so this is the railroad company that owns the land. They say, appellants first observe that the airspace above terminal is a valuable property interest. Airspace. So why are they focusing on airspace? Because they are trying to show that this is a physical interference. I mean, landmark law, people will think, oh, okay, that is a restriction on just the quality. But the appellant is saying, no, it's not just about quality, it's about space. It's not about design, it's about space. We own this much space, now we cannot use it. Remember, physical interference, it was one of the elements that the court looked at in deciding whether something is taking or not. Secondly, appellants argue that the law effects taking because its operation has significantly diminished the value of the terminal site. Appellants argue that New York City's regulation of individual landmarks is fundamentally different from zoning or from historic district legislation because the controls imposed by New York City's law apply only to individuals who own selected properties. So zoning affects an area, but landmark law affects individual owners. So it's more focused. The burden is more focused on the selected owners. So let's look at those two arguments first. What does the court say about this airspace invasion? All the way at the bottom of page 311, the court says, our jurisprudence does not divide a single parcel into discrete segments and attempt to determine whether the rights in a particular segment have been entirely abrogated. Okay? So, the court wants to look at the property as a whole. Doesn't want to carve out part of the property and says, okay, that space cannot be used, so, right? So the restriction is physical because the entire space is not usable now. That argument cannot be made. That's what the court is saying, right? It makes sense. And also, it's not clear whether airspace is actually not usable anymore. Maybe they can build not an office building, but build something in the same design, right? Just build something similar. I don't know, hire Gaudi or somebody, right? Who can continue the aesthetic feel of the original building. They didn't submit that. They wanted to build an office building. The second argument, that this is more individual. What does the court say about that? The third paragraph, right in the middle, contrary to appellant's suggestion, landmark laws are not like discriminatory zoning. That is a land use decision which arbitrarily singles out a particular parcel for different, less favorable treatment than the neighboring ones. In contrast to discriminatory zoning, the New York City law embodies a comprehensive plan to preserve structures of a historic or aesthetic interest wherever they might be found in the city, and over 400 landmarks in 31 historic districts have been designated pursuant to this plan. So, it's not targeted at a certain individual building. This is part of a comprehensive plan. The fact that these individual historic landmarks are not in one area does not change the evaluation. It's a part of a comprehensive plan. So all the way at the bottom, second to the second to the bottom paragraph. In any event, appellants' repeated suggestion that they are solely burdened and unbenefited is factually inaccurate. This contention overlooks the fact that New York City law applies to vast numbers of structures in the city in addition to the terminal. All the structures contained in the 31 historic districts and over 400 individual landmarks, many of which are close to the terminal. So, to decide whether it's taking, the court will look at whether it interferes with investment-backed investment-backed expectation, and also whether it's a physical. So the court already has decided that this is not physical interference. And how about how about whether it undermines the investment-backed expectation? Look at page 313, the third paragraph. We must now consider whether the interference with appellant's property is of such a magnitude that there must be an exercise of eminent domain and compensations to sustain it. That inquiry may be narrowed to question of severity of the impact of the law on the appellant's parcel. And then the court says, the New York City law does not interfere in any way with the present uses of the terminal. Its designation as a landmark contemplates that appellants may continue to use the property precisely as it has been used for the past 65 years. As a railroad terminal containing office space and concessions. So the law does not interfere with what must be regarded as the Penn Central's primary expectation concerning the use of the parcel or its ability to obtain a reasonable return on its investment. All right? So this is how the court resolves the question of investment-backed expectation. What does it mean, investment-backed expectation? Well, expectation at the time of the investment. At the time of investing in the development of that parcel, what were the investors thinking? Well, they were thinking of building a railroad station. And that expectation has not been disappointed by the historic landmark decision. Actually, it promotes the original investment decision, because now being considered historic, it will be promoted by the tourist industry. People will come. Now that it has been designated historic, more tourists will come to Grand Central and will, buy things, eat and drink at Grand Central, which amplifies, which strengthens the current landowners to promote the original expectation of using it as a station, as a railroad station. So that is Grand Central that is Grand Central decision. Let's see. Now, Justice Rehnquist and Chief Justice and Justice Stevens joined. They wrote a dissenting opinion. What's the crux of what's the center of, what's the essence of their dissent? Right, that there is a lot of that's a big burden on individual for whose benefit? For benefit of the public, right? So, page 314, the second to the last paragraph. The final sentence of that paragraph. It is exactly this imposition of a general cost on a few individuals at which the taking protection is directed. So yes, if Grand Central exists, it's good for the whole city of New York, but it's bad for the owner. The owner loses millions of dollars because cannot develop it. That's where, you know, the public has to compensate the private. And this is different from zoning. Page 313 at the bottom. Typical zoning restrictions may, it's true, so limit the prospective uses of a piece of property as to diminish the value of that property in the abstract because it may not be used for forbidden purposes. But any such abstract decrease in value will more than likely be at least partially offset by an increase in value which flows from similar restrictions as to use on neighboring properties. So designating one area residential, yes, will diminish the value in that area, but at the same time, by designating the other district commercial, that means the houses cannot, residence cannot be built in the neighboring area, which means this only residential area will attract people looking to buy residence. So there will be offset, right? And also, you know, people living in residential area, they also want to have some commercial establishment nearby. How does the zoning, so having that commercial area nearby will increase the value of the houses within the residential area. That's what the dissenters are calling at the bottom, average reciprocity of advantages. Reciprocity. There is a give and take. So people lose some, but people also get some. But here people only lose. The landowner of the Penn Central loses so page 315, all the way at the top, the court's saying, not the court, the dissenters are saying, if the cost of preserving Grand Central Terminal was spread evenly across the entire population of the city of New York, the burden per person would be in cents per year. A minor cost appellees would surely concede for the benefit accrued. Instead, however, appellees would impose the entire cost of several $1 million per year on Penn Central. It is precisely this sort of discrimination that the Fifth Amendment prohibits. Okay. What do you think about this? What do you think about dissenters' argument? I mean, if you pass gun control and if you pass smoking ban, yes, the value of guns, the value of tobacco company stock will go down, but thanks to less gun and thanks to less smoking, a lot of people will, including the gun owners. Gun owners could be shot by other guns. Smoking ban will help the smokers as well, because they don't have to inhale the smoking fumes of other smokers. But here, the property owner only loses and doesn't get anything. Well, I think the real answer is the property owner does draw benefit. It is over the time that property owner can continue to draw benefit from the fact of a historic landmark. So think about that, and in the break time, see if there is a similar decision in the Korean Constitutional Court. Okay. All right, we'll take a 15-minute break and we'll start again at 11:45. We'll start with the redevelopment case. Source book, page 327. This is a very interesting case. It's not about property ownership, but it's about right of tenants. The question is whether the tenant's right is also a property right. Okay. I mean, if it's considered a property right, then to be restricted, the government has to pay money, right? So, establishing tenants' right as a property right is good for tenants in the relationship between tenants and owners. So maybe it's good for equality. Let's check. Okay? So 15 minutes. Right.
듀 프로세스를 적용을 한다는 것인지 아니면 듀 프로세스의 문제가 아니다라고 했던 것인지 혹시
오클라호마 케이스 뭐 얘기하는 거지?
그 업티커
여기 부분에 보면 잠깐만 너 이게 292
The days
the days가 여기 이 부분
듀 프로세스를 적용하는데
네.
듀 프로세스 위반은 아니다 이 얘기예요.
적용을 하긴 하는데
듀 프로세스가 당연히 substantive 듀 프로세스 말고는 직업의 자유를 통할을 할 수 있는 조항이 없어요. 미국 헌법은.
네.
그 원래부터 자유는 표현의 자유, 뭐 종교의 자유, 이걸 중심으로 헌법을 만들어 놨기 때문에 일반적인 행동의 자유에 대해서는 그 14th Amendment due process를 통해 가지고 이렇게 임시 방편으로 없는 헌법 조항을 만든 거죠. 그래서 그거를 적용을 하는데 적용해 보니까 이런 법을 우연시키는 내용은 아니다. 이런.
오늘이 마지막 수업 맞는 거죠?
다음 주가 하나 또 있지 않나?
그 어나운스먼트
6월 1일 마지막 노체인지 마지막이고 그다음 6월 20일 시험.
왜 내가 6월 1일이 마지막이라 그랬지? 6월 8일도 수업이 있잖아요. 어나운스먼트 봅시다.
지금 여기 그래서 저희도 8일이 있는 걸로 알았다가 혹시 그 8일 것을 이번 수요일로 옮겼던 것인지 헷갈려서.
아니에요. 8일 거는 남아 있어요.
8일 그럼 한 번 더 요 사이에 있고 그 다음에
내가 6월 1일이
네.
6월 1일이 수업 마지막 수업인 줄 알고 저렇게 써놓은 모양이구나. 예, 6월 8일 날 수업이 있어요. 그 마지막 수업이, 그러니까 그 6월 14일 날이 종강이기 때문에, 잠깐만, 나 다시 한번 확인해 볼게요. 다시 말해봐요.
16주차 중에 2주 시험 기간 빼고 14회에 다음 주 수업
열네 번 하려면 중간고사하고 그렇지. 그러면 7주, 그러니까 중간고사 전에 7번, 그 후에 7번 그렇게 해야 되는데 그 후에 7번 해야 되면 6월 8일 날 해야 될걸?
선생님 해야 되는 게 맞아요. 제가 오늘 세봤는데 해야 돼요.
6월 8일이 7번째 수업이죠. 그래. 자. 맞아요. 내가 빠진 날짜하고 그 보강을 언제 했는지 쭉 적어 놨는데 6월 8일에 대해서는 아무런 얘기가 없어. 네, 맞습니다. 네.
기말고사
네.
혹시 어떻게 내실지 어디에
팩트를 주고 사실관계를 주고 뭐 범위는 그냥 뭐 우리가 읽었던 판례들, 그러니까 참고자료 들어온 거 말고 우리가 실제 읽었던 판례들, 그리고 뭐 오픈북이니까 범위는 뭐 그렇게 중요하진 않은 것 같고, 하여튼 우리가 읽고 토론했던 판례들하고 저기는 시험 형태는 문제 2개 사실관계 주고 논점 포착해서 알고 있는 판례 통해 가지고 해결하는 방식. 네. 노트북 사용 노트북 사용하면 이제 외부인하고 연락을 할 수가 있어 가지고 그게 이제 제일 문제죠. 연락이 안 되게 뭐 이렇게 방해 전파를 쏠 수 있으면 좋겠는데 그걸 하지 말라 그러니까 그런 이유로 노트북을 하는 건 아니지. 네?
찾아보고 이거 답안 영어로 썼어.
잘 안 들려요.
답안 영어로 썼어. 사전은
사전 당연히 봐도 되죠. 근데 사전이 온라인 사전밖에 없어서
그 노트북으로 하면은 좋은 점이 그런 것들을 옆에다가 써놨으니까 키워드로 검색이 자기 노트를 찾기가 빨라서 그렇게 하는 경우가 있거든요. 근데 책으로 보면 페이지를 알아야 되는데 그런 식으로 필기를 하지 않아서
잠깐만요. 뭐 어떻게 할까요? 다 컴퓨터를 쓰기로 할까요? 노트북 쓰는 걸로 했으면 좋겠는 사람. 그냥 손으로 쓰는 걸 했으면 좋겠는 사람. 없고. 근데 뭐 압도적으로 와이파이 차단기를 파네. 한 300불에. 이런 거 있으면.
교수님께서는 연락뿐 아니라 저희가 인터넷도 쓰지 않기로 말씀하셨어요.
그러니까 인터넷을 쓰게 되면, 그러니까 외부인하고 연락을 할 수가 있으니까 그게 제일 문제죠.
그거 말고 인터넷 쓰는 거 검색 같은 것도 원래는 허용을 안 하시니까.
허용했으면 좋겠는데 그 연락 문제 때문에 그게 문제지. 여튼 그거 좀 생각해 봅시다. 네, 생각해 보고 그 재산권 저 뒤로 넘어가서 자, 캘리포니아 케이스. So what happened in this case? page 328, the right column. So Dr. Muller and others operated veterinary practice, so animal doctor, and they it's a little bit complicated, but you know that's what it is. They were operating basically animal hospital, and page 329 to the left column, so second to the last paragraph. The department confirmed that it had decided to department confirmed that it had decided to proceed with the condemnation of the North Main Street parcel. And during the remainder of 1978 and 1979, let's see. The remainder of 1970 and 1979, 3 lines below, it was anticipated that the total cost of the new Street Boulevard facility, including land and improvements, would be approximately $400,000. So the redevelopment was going to take place there. So the rent will go up immediately. I mean, that's what happened to redevelopment, right? Because a new building, the owner, in order to recover the cost of improvement, they increase the rent. Page 329, Dr. Muller was unable to sell, page 329, the third paragraph, Dr. Muller was unable to sell the goodwill of his practice in the face of the impending rent increase. Further, he was unable to close his practice since its goodwill value was a substantial part of his retirement fund. Therefore, he proceeded with the construction of the new building on Street Boulevard. So, Department's condemnation action against North Main parcel went to trial on the issue of compensation in 1981. So, basically, when the condemnation takes place, so this is a redevelopment situation. So the landowners are compensated for the landowners who cannot go ahead with the redevelopment. They have to sell out, so they receive compensation for the land. Now the tenants, right? Tenants who are forced to move out because of the increased rent, they are also compensated for the goodwill. What is the goodwill? Goodwill of who? Goodwill of the customers. So the popularity of the business among the customers is the goodwill. 그러니까 지명도 같은 거, 지명도. 대중적인 지명도. Usually measured by, how popular the customers come, how many customers come to the come to the establishment. Now, whether that is a property has been debated for a long time. The Supreme Court actually decided, the US Supreme Court decided that goodwill is not a property. So, for instance, if okay, let's go to smoking ban again. Let's say smoking ban is passed by the government, and people will not come to this tobacco shop as well as they did before. That will attack the goodwill, right? That will destroy the goodwill that the tobacco built among the customers. But the government will not be required to compensate for the loss of that goodwill. In response, California, the state of California passed a law together with I believe about 10 states, most of them big ones. They passed a law saying goodwill has to be compensable. So, page 328. The left column. Section 1263.510, like right in the middle, okay, right in the middle. So 1263.510 of California Civil Code. It says, the owner of a business conducted on the property taken or the remainder if such property is a part of a larger parcel shall be compensated for loss of goodwill if the owner proves all of the following. The loss is caused by the taking of the property or the injury to the remainder. The loss cannot be reasonably prevented by a relocation of the business or by taking steps, adopting procedures that reasonable prudent person would take and adopt in preserving the goodwill. Compensation for the loss will not be included in payments under Section 7262 of the Government Code. Compensation for the loss will not be duplicated in the compensation otherwise awarded to the owner. Within the meaning of this article, goodwill consists of benefits that accrue to business as a result of its location, reputation for dependability, skill, quality, and other circumstances resulting in proper retention. 유지한다는 거, 유지. Retention of old or acquisition of new patronage. patronage는 이제 그 애용으로 이제 한국말로 하면 애용이죠, 애용. 그 손님들의 딱 단어가 맞는 단어가 없는데 손님들이 많이 오는 거, 그 상황을 이제 patronage라고 하는 거죠. So then, what is the let's see. So if you look at page 331, the left column, let's see. So just to give you evidence of what I just said, look at page 331 on the left column, the bottom paragraph. The remedial purpose of the statute under consideration is evidence. Section 1263.510 was enacted in 1975 as part of a comprehensive revision of eminent domain law in California. The section was enacted in response to widespread criticism of the injustice wrought by the legislature's historic refusal to compensate condemnees whose ongoing business were diminished in value by a forced relocation. The purpose of the statute was unquestionably to provide monetary compensation for the kind of losses which typically occur when an ongoing small business is forced to move, give up the benefit of its former location. Okay. Now, so that's what's going on, right? So Dr. Muller was running animal hospital, redevelopment, increase the rent prices. So he had to be move out. He had to move out. Now the U.S. Constitution said, goodwill is not property. If it was property, it would have been a taking. Right? And the compensation would have followed because the U.S. Constitution, the U.S. Supreme Court said it's not property, there is no compensation for goodwill. But the state law, California passed a law says, okay, we'll compensate for goodwill, even if it's not a property under the U.S. Constitution. Right? Okay, knowing that, what's the issue here? The page 330, the left column, Dr. Muller testified concerning the reasonableness of expenses at the new location. The expenses which, according to experts, had swallowed the practice's goodwill. He testified that typically veterinary practice is limited geographically to a radius of 5 or 6 miles. People will generally not travel any further, he believed, to take their pets to a veterinarian. In order to keep his clientele, Dr. Muller believed he would have to relocate within a few miles of his old office. This, of course, limited his choice of new sites to downtown Walnut Creek. The move was apparently successfully maintained the patronage of the practice. During the month between the relocation and the trial, there was no loss of either customers or gross income. The jury awarded Dr. Muller $96,000 for the value of the goodwill taken by the condemnation. The department appealed, contending the evidence showed only of loss of profits. Not of goodwill. So, and if you look at the footnote 5, it also awarded him $299,000 for the value of the land and the building at the old location. So the building cost was also compensated. So basically the question is whether, I mean, he did not suffer actually, he did not actually suffer any actual loss. But he lost the excess income that he could have made at the old property. So just read that and read this case this is not a constitutional law decision. This is a statutory decision. This is a statutory law interpretation. I put in there just to show the extra mile that the government is going, the California government is going to protect the tenants, to protect commercial tenants. You know that many tragedies happen in Korea because of lack of protection for the tenants forced out of commercial buildings on redevelopment. They try to hold on to their business, got into fight with the police. People died in Yongsan in a fire. Tragedies continue. Why? Because there is no law protecting the goodwill of the tenants. The law is all about compensating the owners, but not much about compensating the tenants. And we should think about protecting the goodwill of the tenants as a property, given that property right apparently enjoys stronger protection because whenever it's restricted, the government has to pay money. Okay, any question, comment about property right? So remember, public use, okay, that's the big issue. Whether something is for public use, and the other issue is whether something is a taking. I mean, how serious does it have to be to constitute taking? Think of a Penn Central. Okay. All right, let's go to abortion case. Roe versus Wade. Okay, what happened in this case? Page 334 at the bottom. The Texas statutes under attack here make procuring an abortion a crime except by medical advice for the purpose of saving the life of the mother. Which means it just banned abortion unless in an exceptional situation. Okay? What does the court say about this? Under what constitutional provision is freedom to have abortion covered? What constitutional provision will it be covered? Well, we talked about this, right? I mean, there's no other provision to show substantive due process, right? So 14th Amendment, 5th Amendment, both of them say, no life or liberty, property shall be deprived without due process of law. And it's usually, I mean, originally it was about procedural protection, but later constitutional scholars began using it, judges began using it as a substantive restriction on the state's power to interfere with people's liberty in general, which includes, of course, liberty to have abortion. So if you look at page 335 at the bottom, the Constitution does not explicitly mention any right of privacy, but the court has recognized that a right of personal privacy or a guarantee of certain areas, zones of privacy does exist under the Constitution. Blah, blah, blah. In the concept of liberty guaranteed by first section of the 14th Amendment. 이게 이제 substantive due process죠. Liberty. All the way at the bottom line. Page 336 at the top, these decisions make it clear that only personal rights that can be deemed fundamental are included in the guarantee of personal privacy. Right below the second paragraph, the right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty or in the 9th Amendment, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. Okay, so the court kind of framed it so that liberty will include someone's right to have abortion. And given that, what standard of review should it be applied? Strict scrutiny. 1, 2, 3, fourth paragraph, right? One paragraph down from the midpoint of the page, where certain fundamental rights are involved, the court has held regulation limiting these rights may be justified only by a compelling state interest, and that legislative enactments must be narrowly drawn to express only the legitimate state interest at stake. Okay. Having said that, what's the purpose of, so once you identified what standard of review, so I mean, let's track back. So on page 335, the court talks about the right of privacy, and then going on to 336, I mean, on 335, the court says privacy somewhere, right? Privacy is somewhere included in the Constitution as a basic right, and it is part of the liberty in the 14th Amendment, when which says, no life, liberty, or property shall be deprived without due process of law. Going on to 336, the court says, hey, privacy does include woman's right to have abortion. And because privacy is fundamental, the strict scrutiny has to be apply. Now the question then is strict scrutiny requires the state action to have compelling governmental interest, and state action to be narrowly tailored. Then the first thing that you have to do is look at what the government interest is in banning abortion. What interest does the court identify?
It has its right to life.
Yep. Protection of life of what? A person or fetus, yes. What's the compelling government interest? Protection of life of fetus. Now, having said that, the second paragraph from the page 336 from the second paragraph, the appellee argues that the fetus is a person within the language in the meaning of the 14th Amendment. If this suggestion of personhood is established, appellant's case collapses, for the fetus' right to life would then be guaranteed specifically by the amendment. Right? 14th Amendment says life, liberty, and property. Life is specifically guaranteed. So protecting life of a fetus, if it's a person, then it will of course meet the compelling governmental interest. If it's a person. Does the court say it is a person? What do you think? Page 958, the second paragraph from the top. All this, together with our observation that throughout the major portion of the 19th century, prevailing legal abortion practices were far freer than they are today, persuade us that the word person as used in the 14th Amendment does not include the unborn. Okay? So, the interest of protection of life may be compelling, but not compelling like protecting person's life. Does the court still say it is an important right? I mean, it is an important governmental interest to protect the life of fetus? Exactly. So, if you look at page 958, the second paragraph toward the bottom, it is reasonable and appropriate for a state to decide that at some point in time, another interest, that of the health of the mother, or that of potential human life, becomes significantly involved. So protection of a life of fetus, not as a person, okay, not as a person, but as what? As potentiality of a person. What the court is saying is, hey, let's say man and woman had sex and the conception happened. The night after, Is there compelling governmental interest in justifying the state prohibiting the woman from having abortion, like one night after the sex, one night after the conception? No. But it is a potentiality, there is a potential for that small thing in the woman's body to become a human being. So that is an important interest, but does it become compelling enough? I mean, is it compelling enough to justify ruining woman's life? Let's look at page 957. The second paragraph, underlined part. The detriment that the state would impose upon the pregnant woman by denying this choice altogether is apparent. Specific and direct harm, medically diagnosable, even in early pregnancy, may be involved. Maternity or additional offspring may force upon the woman a distressful life and future. So, health-wise, pregnancy can also be burdensome for women. You know, just as abortion can be dangerous, remaining pregnant can also be dangerous. And also raising children, right, is distressful. Psychological harm may be imminent. Mental and physical health may be taxed by childcare. There is also the distress for all concerned. Associated with the unwanted child, there is the problem of bringing a child into family already unable, psychologically and otherwise, to care for it. So a lot of bad things can happen in unwanted birth. So to justify forcing people to go into this tragedy, there has to be compelling interest. The court is saying, hey, it's important to protect fetus, but not so much as important as protecting it as a person, but protecting it as a potentiality of life. Potentiality of a person. When does the potentiality of a person become important enough? Page 337. Third paragraph from the bottom. Viability is usually placed at about 7 months, but may occur earlier, even at 24 weeks. Catholic Church recognized the existence of life from the moment of conception. So, go to page 959. Fourth paragraph. With respect to the interest in potential life, the compelling point is at viability. That's when potentiality comes close enough to actual personhood, right? This is so because the fetus then presumably has the capability of a meaningful life outside the mother's womb. State regulation protective of fetal life after viability thus has been both logical, biological justification. If the state is interested in protecting fetal life during the period, it may go so far as to prescribe abortion during the period, except when it's necessary to preserve the life or health of the mother. So this is how the court envisions the constitutional balancing. This is the passage of time, and this is interest, and this is the point of conception. Okay, this is where the mother and father had the sex, and the interest in protecting the life of fetus as a potentiality of person increases. And when it hits the point of viability, viability means ability to live alone, ability to survive on its own. At the point of viability, which comes like 24th week, right? 24th week. Or 28th week. Then it is compelling enough. So after that, right? So if you divide the pregnancy of 10 months, this is T1, trimester 1, trimester 2. Trimester means splitting a year or splitting the period into 3. So first trimester, second trimester, and third trimester. Each trimester being like 3 months. 3 months here, 3 months there, 3 months there. I mean, like 3.5 months or something like that. And 6 months is like, 28 weeks. So after this, abortion can be banned because the government has compelling government interest in justifying state's action of forcing women to go through all the hardship that we just read. Because their potentiality of human life, the potentiality of a person is just so great. Okay? So this is the first time that you looked at how the constitutional balancing changes over time. And it has to change over time if you think scientifically about it, because the importance of fetus, of course, changes. The night after sex and few months after the pregnancy where, the mother is communicating with the fetus. Of course, state interest in protecting the fetus changes depending on how close it is to the personhood. Make sense? So it's more like 3.5 months. So this 7 months, so that's closer to 28 weeks. Now, does this mean that the state cannot do anything before, during the first and second trimester, before the fetus before the interest in protection of fetus becomes compelling? What can the state do in the first and second trimester? Well, they can do things to protect what? Woman's health. Protect mother's health. The idea is that abortion can be dangerous. Then when does it become more dangerous? (959), the second paragraph. With respect to the interest in the health of the mother, the compelling point in light of the present medical knowledge is at approximately the end of the first trimester. The end of the first trimester. So, there's another interest. Again, grows, but it grows much faster. At the end of the trimester, it becomes compelling. Okay, sorry, this is I have to write viability here. And this is the compelling point. When does it become compelling? The potentiality of personhood becomes compelling on the 28th week. The mother's health, the threat to mother health becomes compelling after the first trimester. Okay, well, if the state already has compelling interest to protect mother's health, why not ban abortion? Can the state ban abortion to protect mother's health after the first trimester? What is the court saying? I mean, the court is saying, hey, the interest in potentiality of human life is potentiality of a personhood is important enough that abortion can be banned after the second trimester. Couldn't the court say the same thing about interest in woman's health? Hey, it has become compelling, so to protect women, we have to ban abortion. Why not? What does the court say about that? See, compelling government interest is only half the constitutional balancing. This is the end test. End. 목적 심사. What do you have to do other than that? Well, you have to do means test. So court is saying, yes, woman's health is a compelling interest to protect, but the restriction has to be narrowly tailored for protecting woman's health. Which means banning abortion may be unnecessary, right? Maybe you can protect woman's health while allowing her to go through abortion. As long as abortion is done safely, the compelling interest in woman's health is protected. That's why the court is saying, the third paragraph on page 959. This means, on the other hand, that for the period of pregnancy prior to this compelling point, the attending physician in consultation with his patient, 959, the second paragraph. It follows, second paragraph right in the middle, it follows that from and after this point, state may regulate the abortion procedure to the extent that the regulation reasonably relates to the preservation and protection of maternal health. Examples of permissive state regulation in this area: requirements as to the qualification of the person who is to perform the abortion and the facility in which procedure is to be performed and the like. So that's how the state can protect its compelling interest in woman's health. So they cannot ban abortion. They can only regulate medical procedure by which abortion is taken. So that is Roe vs. Wade for you. Any question, comment? So when you get an exam question, the interest, the government interest may change over time. It can become dynamic like this. And depending on what interest, the response has to be narrowly tailored. If it's really about women's health, well, you shouldn't be able to ban abortion. That's too much. You can only make sure that abortion is done safely. Okay, we're going to end a little bit early today because we covered a lot of cases. Who has read the part behind this? No, right? Okay. I sent you other cases. I may have sent you too many, but just skim through them. It's on Blackboard. It should be on Blackboard. It deals with other rights, other basic rights that I plan to cover. I made that plan only lately, so I'm distributing to you now. Last year when I taught the class, I taught it more as a comparison to Korean constitutional law. So that's why you look at the areas of law that have special relevance to Korean constitutional law. But this year I decided that I'll focus just more on American law, which means some of the decisions which are not that different from Korean law will be also covered. See, when I was doing comparative constitutional law, I skipped everything where Korean constitutional law and American constitutional law comes out the same. Because you don't need to go through that because you learn the same thing. I try to focus on the laws where Korean law and American law differ, okay, have difference. That was the previous plan, but now I wanted to show you kind of fuller spectrum of rights protected under American constitutional law. So we're going to talk about education, we're going to talk about welfare benefits, we're going to talk about the voting rights. These are all the so-called fundamental rights that trigger special scrutiny. Okay, well, strict scrutiny. Okay. All right, thank you. It's 1 o'clock. I'll see you next week.